Hello, everyone. We have an opposition from Wayfarer to WME and their motion for continued sealing, and it's a really good opposition. It's quite telling as well. So, dear Judge Lyman, the Wayfarer parties write in response to non-party WME's motion for sealing. Not one of WME's requests meets the Second Circuit's high standard for sealing at this stage. WME is a world-famous talent agency. It represented Blake Lively and Ryan Reynolds at all relevant times. Contrary to WME's motion, its former chairman, Patrick Whitesell, was listed in the party's initial disclosures. So if you remember, WME claimed that he wasn't. He actually was. And then they point to the dockets and say that, basically Whitesell having knowledge of the party's alleged conduct, efforts taken to market or promote the film, publicity surrounding the film, complaints, or discussions about the work environment or conduct on the set of the film. Baldoni and Lively's WME agents were also included in the party's initial disclosures and similarly identified as to their relevant knowledge, and both were deposed. WME seeks to seal or redact communications that bear substantively and directly on the issues now before the court. For instance, WME seeks to withhold portions of documents that reflect communications in which WME's agents not only confirm the Wayfarer party's account of events, but also make clear, among other things, that 1, redacted, and 2, redacted. The documents also bear on Lively's damages claims, redacted, in the precise period of time during which Lively alleges her reputation was damaged. WME's role is not tangential. The communications make clear that WME and its agents were intimately involved in managing the tensions on set and later during the film's premiere, and that they were far from neutral parties when those tensions erupted in a public dispute. Interesting. WME claims its privacy interests are high because the redacted material is not already public. But as this court recognizes in its own individual rules, the mere fact that information has previously been kept confidential is not, by itself, a valid basis to overcome the presumption in favor of public access to judicial documents. WME has failed to identify any actual privacy interest, much less any interest that would outweigh the strong presumption in favor of public access to summary judgment materials. The names of the WME parties involved have already been publicly disclosed. The information at issue does not concern anything especially personal, such as medical information or anything competitively sensitive, nor has WME identified any other personal or professional risk that might result from disclosure beyond a vague reference to the media-driven nature of this case. As this court has acknowledged, a generalized concern of adverse publicity is not, however, a sufficiently compelling reason to outweigh the presumption of access. WME's other arguments for sealing are similarly off base. It asserts the documents should be sealed because they may not be admissible at trial. But the presumption of public access and the reasoning of Lugosz and its progeny are directed to different concerns than the federal rules of evidence. Even documents a court deems wholly inadmissible still become part of the record and can still inform a public's understanding of the judicial function. In any event, WME's view of admissibility is overly cramped in assuming that if its agents had no personal knowledge of what happened on the set, the documents cannot come in. This case raises a host of broader issues, including how Lively's conduct affected the production, marketing, and publicity around the film, and the events leading up to the defendant's decision to hire Crisis PR. The nuances of admissibility can be addressed at a later stage. WME claims that its agents were simply acting as advocates for their clients, but that is not a justification for sealing and only underscores the importance of the documents. A key issue in this case is the extent and manner in which Lively used her considerable power and industry influence, redacted, against the Wayfarer parties. Okay. WME further argues its communications with Reynolds about these issues should be sealed because he is not a party to this case. Yet WME does not explain how WME itself might suffer competitive harm or any other cognizable privacy injury should this information be made public, nor does it articulate any harm that might befall Reynolds. Moreover, as explained in the Wayfarer party's opposition to Lively's motion to seal, the claim that Reynolds is a non-party whose communications should be sealed is overly restrictive and absurd. In the documents at issue, redacted. Especially given that Lively has asserted marital privilege over her communications with Reynolds. Reynolds' communications with others, redacted, are crucial to the Wayfarer party's defense. And that's why he was not deposed. Why would you waste hours of a deposition for him to keep invoking spousal privilege? Why would you? You go to other people. You go to people like WME. That's why they did it. So yeah, it's ridiculous for Lively to sort of be, filing documents saying, well, he offered to make himself available for a deposition, but she invoked spousal privilege and she just neglected to mention that. The messages are cited throughout and form an integral part of the Wayfarer party's summary judgment briefs. For these reasons, and those stated in opposition to Lively's sealing motion, these documents should not be sealed. Finally, WME seeks to seal documents that disclose the commission it obtained from Lively's work on the film. Notably, WME does not claim this rate is confidential or competitively sensitive because it is not. Rather, WME charges the industry standard rate dictated by California's Talent Agencies Act. Because Lively's compensation is material and relevant to the question of whether she was an independent contractor and to questions concerning the extent to which she was damaged or benefited from her participation in the film, this material should not be sealed. Oh, interesting. I think that's a really good filing. That's a really good opposition. Have to see how that one plays out. But I learned a new load of information there in, Lively invoked spousal privilege, and WME Patrick Whitesell specifically was actually named as a person with knowledge, which is the opposite of what they're claiming. And I never really got their argument anyway about redacting his stuff, because when the exhibit that included his text messages, his messages were unredacted. So I wasn't quite sure what they were sort of arguing for. It made no sense. Okay. There's a couple more filings, and I've got something I've got another filing I'll do tonight, and then I've got one for tomorrow, which actually dropped yesterday, but my little one's had her surgery today, so I'm trying to juggle everything. But I'll be back later with another video.